in similar vein, along the same thinking, along the same paradigm, to strictly enforce when you retire to make your decision, to strictly enforce Rule 19. Rule 19 of the standing order, Rule 19 of the fifth schedule to the standing order, provides reads as follows: in presenting its evidence, the assembly shall, and it uses a mandatory phraseology, shall not introduce any new evidence that was not part of the allegations against the governor by the county assembly, as forwarded by the Speaker of the County Assembly to the Senate, to the Speaker of the Senate. Now, this clause is very significant, and we insist shall be strictly enforced against the County Assembly, so that we are also equal, and we are seen that we have done justice both to the County Assembly and to the County Executive in terms of complying with the rules governing impeachment. Now, in yesterday's proceedings, during the cross-examination of the first witness of the County Assembly, the following issues transpired, and it's there in the Hansard. And again, I want to repeat it for the record so that my points are seen in context. That there are certain documents which were not given to the governor, and they were not part of the allegations which the mover of the motion introduced in the County Assembly. And these documents were later introduced. They were not part of the package of the complaint which was given to the governor at the County Assembly. They were introduced in the Senate. They were introduced as an afterthought, later on in the Senate, to package and reframe a case which is definitely weak in terms of want of documents, and also in terms of the consistency in terms of content of the documentation. Now, these are the documents which were not given to the governor. And remember, the right of the governor to the County Assembly, to appear in the County Assembly, is so sacrosanct that that right cannot be taken away. And the Senate, when inquiring in these impeachment proceedings, you have to be bold enough and make a decision that breach of such a right in the County Assembly is in itself a reason to invalidate the entire proceedings of the County Assembly. And therefore, the Senate then can't consider these proceedings, because then it sets a dangerous precedent that a County Assembly can run roughshod and take impeachment in a casual manner outside the provisions of its own standing orders, disregarding the Constitution, Article 50, disregarding the provisions of the Fair Administrative Action Act, and then submit these impeachment proceedings to the Senate, and then hope the Senate will clean up that mess. We must ensure and push for strict compliance of the Constitution and law. So this is really the problem. Standing Order number 90 of the County Assembly of Kiambu Standing Orders. In the morning, they submitted that there's no such clause in the standing orders. And I submit that there's an express provision in the standing order number 90, which provides for documents to be given to the governor. When a person who is facing removal proceedings, the standing order provides, must be given adequate notification of the allegations against that person. So the governor, in extension, must be given notice of the motion. And in that notice of the motion, which has been moved by the move of the motion, the notice, attached to that notice of the motions are documentation. So they form a package. It is this complaint which is given to the County Assembly to make a decision on. Now, this complaint serves as sufficient notice to the governor so that he understands his rights and then can prepare adequately to push his defense through. So if these documents have been given to the governor and a decision has been made, by the county assembly, we can equate that to a principle in law known as the functus officio. Then the county assembly decision is final. It is that decision in terms of documentation which the Senate then proceeds on. So it is important then that the county assembly cannot introduce additional documentation. Why are we submitting that the county assembly cannot introduce additional documentation? It's because they'll be doing what we call a fishing expedition, introducing new evidence, and then that prejudices the case of the governor, given the manner in which Section 33 of the County Government Act has been coached and the manner in which the standing orders have been crafted. It heavily prejudices the rights of the governor. So in submission, the following documents were not given to the governor, and the burden is on the county assembly to prove. Lucky for us, they made an express and clear and unequivocal admission. Page 1 of the county assembly bundle, they have admitted this document was not given to the governor. Page 2 of the county assembly bundle, page 3 of the county assembly bundle, the report of the Auditor General was not given to the governor. Even though it's a report which is easily available in the website, it was not given to the governor as part of that sequence of complaints by the county assembly in the allegations, so that the governor can then be adequately notified of these allegations and prepare a response accordingly. Page 37 of the county assembly bundle, there's an admission on record. It was not given to the governor. Page 50, the document at page 50, all the way to page 64. These documents were not part of the complaints, part of the allegations against the governor in the county assembly. Page 76, again, is a document which goes all the way to page 125, one single document, not given to the governor. Page 1, all the documents from page 125 onwards to the tail end of the county assembly bundle. Again, these documents too were not given to the governor as part of the allegations. And our interpretation of Standing Order number 19 is that the allegations which the Senate Standing Orders is expressed about is the complete package of documentation at the county assembly. And therefore, as we speak, the rights of the governor, which are guaranteed by Article 51 of the Constitution. Article 51 of the Constitution supplants the standing orders. It says, every person has the right to a dispute that can be resolved through the application of law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal or body, such that what transpired in the county assembly, because the proceedings in the county assembly, impeachment proceedings, are quasi-judicial proceedings, removal proceedings. And therefore, the provisions of Article 51 definitely apply. So the implication is that Article 51 has been breached, and the entire provisions of the Fair Administrative Action too have been breached. And therefore, it's on that basis that I submit that when you retire to make your decision, it's a solemn duty. These are your own standing orders. Standing Order number 1 of 1-2 of this House provides that the decisions which have been made in this House are guided by the Constitution, statute law, usages, forms, precedents, customs, procedures, traditions, and traditions of Parliament. So the question that we are posing to the Senate is, again, a technical question, a technical legal question. Can the Senate proceed to make a decision on impeachment proceedings, a decision on a motion whose content procedure has been tainted with breach of fundamental rules of natural justice? That's the question, legal question. And for us, from the governor's side, we are prepared to dig into that issue all the way so that we get the real answer in terms of how we deal with that question. And we are persuading you to definitely rule in our favor in this plea before the Senate, because it can't be wished away. Remember, Impeachment proceedings are political proceedings, but they are also governed by the law. Now, the second question which is tied to that question of documentation is the right to be heard. The right to be heard. Again, evidence was submitted yesterday before the Senate. It's on the Hansard, that the governor was served with the documentation. And he chose to send his legal counsel according to the standing order. He didn't appear in person. He chose to send his legal counsel. But the county assembly conducted the proceedings in a very cavalier manner, in total disregard of the fact that the proceedings were quasi-judicial in nature, and therefore the county governor deserved to be heard, to make a commentary. According to standing number 90 of the County Assembly of Kiambu standing orders, the governor had a right to be heard, at least for 2 hours, before a decision of the County Assembly was made. So again, it's on record that the governor was not heard by the County Assembly. The councils who are sent to represent the governor were not heard. So is that breach of the right to be heard and the right to be represented by council in such a manner such significant that it triggers a decision by this Senate in the negative against the County Assembly? I submit yes. It is something that you can't ignore. It must be in your decision, because the entire proceedings then have been tainted in that manner. So we are submitting that everyone is equal before the law. The same standard which was used to deny the county governor documents in the morning must be used to gauge the applicability of the standing order number 19, so that we are seen to be equal before the law, and that decisions are not made with express discrimination, implied discrimination, because then questions regarding equality, fairness, and justice will then come in time for consideration. And I submit that when you make that decision, you need to be devoid of any other consideration in your mind. You need to only look at the Constitution and law and the standing orders. Political considerations aside, you need to make decisions like you're going to deliver justice for the governor, like you are standing at Armageddon and battling for the Lord of justice. Article 7 of the Universal Declaration of Human Rights contains that sacrosanct right of the right to be heard, equality before the law. We need to be fair to the governor. Notwithstanding the political considerations that cloud this impeachment, tomorrow you'll be the one on the governor's seat, and will be here defending you as a senator when you become governor regarding the allegations, because the Constitution is what we follow. So we insist that we don't take on board political considerations, but only legal considerations, so that we make a decision which is conceptually satisfying, a decision which serves future generation, and a decision which is informed by this country's, by this House precedents. Now, yes, in yesterday's testimony, again, we are making a commentary on the County Assembly case. Mr. Nani Mungai, who is a fairly senior lawyer in this country, when he stood up to make the introduction regarding the County Assembly case, he made an opening which seemed to create the impression that the House is on fire. That is the impression that he created in his opening statement. And if you are coming to this universe for the first time, you will be so alarmed by the statement that he made in the initial opening remarks. But then what evidence was submitted to buttress the heavy opening statement which he made? And by the way, for out of record, Nani Mungai is a very senior lawyer. I don't think the County Assembly can afford his legal fees. But that is not the point. So the evidence which was submitted before the County Assembly, this is the evidence which was submitted before the County Assembly. In summary of the evidence, because I want to link this to the question of threshold. The county assembly submitted a 154-page documents. And in my submission, I've explained that more than 75% of the documents in this county assembly bundle are supposed to be expunged. And when you try to consider, please consider those submissions. But then the documentation which they submitted, are these documents strong enough to meet the constitutional threshold for impeachment of governor? Did the testimony which was adduced by the county assembly in terms of threshold, through their key witness, the first witness, because that's the star witness, does that evidence meet the threshold which has been set by the Court of Appeal and this House in terms of the threshold for removal of a governor who enjoys the right to hold office under Article 38 of the Constitution? Now, this is what transpired, and we have a duty to say this. In cross-examination of the star witness, the counsel for the governor, my colleague, Mr. Ngaga, asked the county assembly star witness 49 questions regarding the completeness of this documentation. 49 questions. Out of these 49 questions, the county assembly witness, the star witness, admitted 47 times that the documents which will have been needed to beef up these allegations against the governor, 47 times, were not in this bundle, they were elsewhere. What does that tell you in terms of the quality of the presentation and the threshold for impeachment in terms of Article 181 of the Constitution? This is the only logical inference you can make from that. The Senate being a house of record, you cannot proceed on assumptions, what-ifs, and suppositions. You must proceed on the documents which are before the House. It must be documents which have been submitted by the county assembly, and for evidential purposes, even though you are not governed by the rules of evidence strictly, the rules of evidence require that you can only be persuaded by the documents which have been submitted before you, and not elsewhere. Of course, the exception will be that if those documents have been produced by someone who has been summoned by the Senate in its inquiry power to give evidence before the Senate. For instance, if the Auditor General had been summoned to give evidence regarding the quality of his statement with respect to the pending bills. So the inference which can be made from that kind of evidence which is not complete, there is no report of the Auditor General in terms of detailed analysis. So there's no testimony of the Auditor General in terms of detailed analysis to explain how these pending bills occurred. There's no financial statement from the county government showing, proving these allegations. There's no procurement plan which was submitted by the county assembly before this House for you to make an inference that procurements which were done by the county government under the provisions of, as complained from page 49 onwards of the county assembly document, was not done properly. There is no approved budget before this county assembly, for the county assembly, before this Senate, for the Senate to make an inference as to whether the quantity of work procured vis-a-vis the budget, there's a variance, as it were. There's no documentation to that effect. There are no tender documents which were submitted before this Senate. What we hear are political statements outside there. No tender documentation, no single tender document, no letter of award. The procurement person who was supposed to be the third witness parachuted, and we were waiting for him to ask him those questions. But he declined. The acting procurement director, the third witness of the county assembly, he parachuted out of these proceedings and declined to testify. Because we wanted to ask him, that acting director, he's the person in charge of procurement. How can he make these heavy allegations against the governor without documentation? Where are these documents so the Senate can subpoena and get these documents before the House for scrutiny and ascertain the serious allegations which have been made against the governor? Where are these documentation? So on what basis then are we going to make a determination on those questions regarding culpability of the governor without documents and where the key witnesses who are supposed to testify before the House have not testified. So that leads to only one conclusion, that the evidence by the County Assembly is weak, and it looks like they hurried these proceedings. The impeachment was done in a hurry, maybe as a result of political motivation, as opposed to a genuine legal concern regarding the state of affairs in Kiambu County. So the evidence is not complete as it is. We have appeared before this House in many instances where huge documents have been produced before the House, analysis have been done, senators have asked questions, and responses have been made. And like I'm submitting, I'm telling you, this is not the document. This is not the document that can be used to impeach the governor. There is really nothing here that, in terms of content, that meets the constitutional threshold in Article 181 of the Constitution. Article 181 of the Constitution talks about gross violation of the Constitution. And in accordance with the Court of Appeal decision in the Wambora case, and this decision in Mwangi Wairia and Professor Chepkonyi's decision, the meaning of the word gross is that we are supposed to make an inference from the facts submitted before the House and show nexus with the governor, that the governor is directly attributed to this complaint before the House. That in the complaint before the House, you can see the footprint of the governor. That you can see these tenders. Remember, these tenders were not given to us. You can see, when you examine the tenders, you can see the nexus between the governor and those tenders. You will need testimony from the Director of Procurement. He is the person, if you look at the independent mechanism in which county public finance management works, and county public finance, procurement, you will need the evidence of a procurement person, the evidence of a procurement officer, or the Director of Procurement, to tell us the status of procurement in Kiambu County. How is it done? How is it influenced? Without that evidence, how can you make a conclusion that the governor breached the provisions of the county, of the Public Finance Management Act? In addition, there are other adequate mechanisms. If you look at the Public Finance Management Act, the governor is only mentioned 3 times. Public Finance Management Act. There's a complete regime for public finance management where the ultimate accountability and responsibility lies to a chief officer of finance and county executive committee member for finance. If you look at the entire provisions of the Public Finance Management Act, they have expressed statutory obligations regarding management of public funds. The governor is only a political head. If you look at Article 185 of the Constitution, 185.3 of the Constitution, the County Assembly has powers to do oversight over the county executive. What that means is that, and you could see from the testimony of the star witness, witness number 1, is that there appears to be no engagement between the county executive, the County Assembly of Kiambu and the county executive regarding the status of public finance management in the county. So whose failure is that in terms of oversight? When there is failure of oversight by the County Assembly, so that in terms of oversight, why can they oversight first? Why can they ask questions? Where are these summons which they send pursuant to the provisions of the Constitution? Remember, a county assembly has full powers under the sun to summon anyone to appear before it to answer questions on county public finance management. So where are these evidence that they have attempted to undertake these investigations? They have made recommendations which have been ignored by the county executive, and therefore they can now proceed to undertake the precipitate action of impeachment. Because to me, impeachment is a precipitate action, as opposed to, in this case, a knee-jerk reaction. It's a precipitate action which requires a methodical presentation of issues. You must satisfy this Senate that you have attempted to do what you can do, and of the motion makes 47 admissions out of 49 questions which are asked by him, stating expressly and clearly that these documents are outside there, that he should have done a better job given time by this Senate to. If he was given time, he could have done a better job. So that is the context in which we are looking at these issues. And they must be considered. And therefore, this is the threshold which this House adopted, and its precedent which binds this House in this decision-making. That the allegations must be serious, substantial, and weighty. As I submitted, where the documentation is incomplete, you require further analysis or investigation for you to make a conclusion, then you have to halt your further proceedings. The violation must be flagrant, glaring, and it must be flagrant and glaring, Again, that is very, very critical. There was no witness from the County Public Service Board. As I said, the only instance in these impeachment proceedings where the County Assembly attempted to cast some level of violation of the governor was when they accused the governor of having appointed staff illegally. That was the only instance where they came close. So it left us to one question. What really happened regarding this impeachment? What happened? Where is this testimony from the County Public Service Board to complete the narrative? Is this testimony not available as we speak now? Does Kiambu County Public Service Board, don't they have board members who can be subpoenaed to come before the Senate to assist this House to make a decision? So that was the closest they can get, but there is nothing. In terms of content, they didn't complete the narrative. In essence, they never discharged their burden. As I said, these are quasi-judicial proceedings, but the County Assembly still has a burden to discharge when they are prosecuting the case against the governor. It is not the governor to discharge his own burden by calling the County Public Service Board to come and testify. It is the County Assembly. You are the one in control of the impeachment, and therefore you are entitled lawfully and constitutionally to bring that evidence here, so that the House can make a conclusion on what really transpired. Remember, some of the officers who the County Assembly accuses the governor of having illegally appointing are advisors in the governor's office. Advisors in the governor's office help the governor to execute a political and a legal mandate. And therefore, they are directly appointed by the governor. If you see the signature of the governor, then it means that person has been appointed directly by the governor under the pleasure doctrine, which is applicable in our constitutional dispensation, where as the head of the executive of the county level, elected in a presidential system of government that we have now, then you are entitled to form your own advisors and directly appointing them. So you can't be faulted. So where is this narrative? Where is this completeness? Secondly, Article 179(4) of the Constitution provides that the governor is the chief executive officer of the county. Now, this begs the question, what are the powers of a chief executive officer of a county government? Can that chief executive officer sign an appointment letter? Can he? So it's a legal question. Our submission is that as chief executive officer of a county government, the governor has all powers under the sun to sign documentation. So you can see that if evidence of wrongdoing is not brought by the county assembly regarding those appointments, then it leaves no doubt. It leaves no doubt that the county assembly has not given us the complete story, the complete narrative, so that we can make our own conclusion and determine whether there was wrongdoing or not. So we submit respectfully that the evidence by the county assembly in summary is not complete. First of all, we submit that you don't consider the documentation which the county assembly submitted, and they never gave to the governor, because the governor's rights will be heavily prejudiced. This Senate has an obligation, express, clear, to uphold the Constitution. And if there's a violation of the Constitution during this impeachment proceeding, then we submit that you exercise your obligation to defend this Constitution. If there's nothing else, really, we have to defend this Constitution, the obligation to respect, uphold, and defend the Constitution, Article 3 of the Constitution. We are highlighting that because it's very important. We're also submitting in summary that the governor was not given a fair trial at the county assembly, and the Senate can't turn a blind eye on the fact that the governor was not given a fair trial at the county assembly, because then it sets a dangerous precedent in the application of law in this country, and we will then, in terms of impeachment, lay a basis where there is frivolous impeachment of governors at the instigation of their opponents. So the county assemblies must be told the impeachment proceedings must be done strictly according to the law, according to the Constitution, the County Government Act, and their standing orders. And if there's nothing which is clear in their standing orders, or they have deleted a clause in their standing orders, then it is important to emphasize again that the standing orders rank third in time in terms of the hierarchy of legal norms. The Constitution ranks first. The right to be heard is there in the Constitution. It's then there in the legislation. So if the standing orders don't provide for it, you don't enforce the standing orders. Instead, you enforce the Constitution and the provision of the County Government Act and the provision of the Fair Administrative Action Act, which really provides for fairness, equality, and justice. And that's what the governor is here for, justice. And thirdly, and lastly, we submit that the threshold for impeachment hasn't been met. You have seen the evidence for yourself, the express admissions on record, and the nature and character of the issues which have been put before this House for consideration. And our submission is that the documentation is inherently open-textured. So many gaps in the documents. So many things are required to fill this documentation. You cannot make a conclusion. So in penultimate, at the end of the day, you will be required to uphold the law and the Constitution. So we urge that you refrain from political considerations and really make a decision that is just and not convenient, because we are setting this decision for posterity of devolution so that we have a system that works for the benefit of the people of Kiambu. Thank you very much.
I suspect that is all.
Mr. Speaker, sir, I think there's one more, just one point he wants to make in 1 minute, then we sit down.
Speaker, members, it's one of you who said we've been instructed and paid to do a job. So we wish to finish. I don't think that was a statement made to begrudge us on that. But I promise I only need to make one point that Councillor Wanyama was supposed to submit on. But I think in the heat of the emotion of submission, he forgot. He submits very passionately about devolution issues. That issue is nothing more than Article 50, Subrule 1, that provides that every person has a right to have a dispute that can be resolved by application of law decided in a fair public hearing before a court, or if appropriate, another independent and impartial tribunal or body. Another impartial and independent tribunal or body. For purposes of Section 33 of the County Governments Act, the Senate is this body, anticipated under Article 51. Question is, honorable senators, are we independent in considering this matter? Are we guided only by the facts and the law as it relates and regards the issues in this matter? It is not a question the governor asks of you. It is the law. It is the Constitution and the oath you took to be independent in consideration of all matters that fall for your determination. Are you independent in this matter? Are you impartial? Are you impartial? Again, Article 50, Subrule 1, requires of the Senate, sitting as a quasi-judicial body, considering a matter of removal of a governor, to be impartial. Are we being motivated in our consideration by an independence and objectivity of mind as to arrive at a decision that can be empirically verified by any other so or such independent arbitral tribunal or body? Are we impartial? That is a standard required of you by your oath and by the Constitution. And I say that in consideration of the proceedings as related to Governor Waititu. The evidence and the testimony and the facts that have been discussed show the following. Without doubt, there was manifest violation of the standing orders of the County Assembly in passing this resolution. Their standing orders say 14 days, special motion. But for Governor Itito, no need to comply. Let's do 19 days. It's okay. We will go to Senate. Nobody will ask. Standing orders say, for any person facing a removal, give him documents. For Governor Itito, it's okay. We will not give him. He's given a letter saying you can appear on 19th of December personally or by counsel. He obliges, sends 2 advocates. They write a letter. Speaker acknowledges on Hansard. There are 2 counsel representing the governor. What does he do? These are Governor Itito's advocates. They must not be heard. Let them go to the gallery. Let them watch. They must not say anything regarding the facts. They must not say anything regarding the evidence. And that is what transpired. We shall transmit to the Senate. Senate will condemn the governor. The question is, are we impartial? Are we independent? When we came here on a simple matter of documents, and we were directed by the Speaker on how the County Assembly's case shall be done. No issue. Today, a simple application for documents invites a 1-hour deliberation and a vote for the governor. Different standard. Statutory timelines.
Order. I'm not going to allow you to challenge my ruling.
No, I'm not challenging your ruling. I'm commenting on it.
No.
Very well.
I'm also intelligent. Yeah, I have gone to school, so please. Yeah.
I retract.
And good schools and good universities, for that matter.
I retract that, Mr. Speaker. I retract that. The question of, could I proceed?
Proceed.
A fundamental question was raised on whether there's a proper resolution before the House.
What's your point of order, Senator Murkomen?
I have listened to the council, Mr. Speaker, and respectfully disagree with those who say that he cannot express his dissatisfaction with our ruling. Remember, Mr. Speaker, this is a house of record, and the record of this house might be subject of further scrutiny outside this house. So, Mr. Speaker, respectfully, we must allow the council to disagree with our ruling for the record. Then he will take up the matter elsewhere. But it will not reverse your ruling. The truth of the matter is that your ruling is final. But his disagreement with your ruling must be allowed to go on record.
Senator Mtula Kilonzo Jr.
It's not the disagreement, it's the manner in which my dear friend has treated these honorable members. He says we sat on a simple matter for an hour, and then came up with a very casual deliberation. That is what I am objecting to. It just is casting aspersions on members of this House. He can disagree with you in a manner that is fits decorum a little bit. We're just trying to help you to say what you are dissatisfied with without painting as black.
Okay, I think I've made a ruling on that. Proceed.
I'm guided. I was just making a point on the different manners in which 2 applications of a civil nature were treated. Now, we raised an important issue about the integrity of the vote that culminated in the resolution. And we have made the point that the required threshold required by statute was not attained. It is our hope, even as we submit on behalf of the governor, that that is a matter that the Senate will take up in its investigative mandate with seriousness, the seriousness it deserves, and ensure that the truth and nothing but the truth of those proceedings is finally demonstrated and shown for all and sundry to see and comment on. In the course of our submissions, we have also shown that the grounds on which the charges are premised against Governor Waititu are grounds that have been previously canvassed, not really litigated, but canvassed before this House with certain determinable conclusions that have been consistently applied in over 7 previous proceedings. I'm still at Article 50. Article 50, Rule 1. The right to any party is for a fair hearing. Fairness in its simplicity simply says what is good for the goose is good for the gander. What is good for 7 other governors should be good also for Governor Waititu as a standard. And that is our simple plea and our simple submission and request. With regard to the question of refusal to admit certain documents, fair enough, the decision is final. But as counsel, my colleague, Mr. Wanyama has demonstrated, there was an admission in the open by the county assembly that we have filed additional documents outside the standing orders. There was an admission by the witnesses that yes, that document was not available in the county assembly. We are bringing it here for the first time against the standing orders. Those documents have been considered, have been appropriated in the proceedings. They were not removed, they were not expunged, but our application for additional documents was refused. We do not contest the finality of the ruling by the House, but we suggest, and this is a submission we make, that those circumstances are not fair to the governor. We therefore close our case with that submission, that the Constitution of this country, which establishes all our offices, including the office of senator, requires for observance in all respects. Article 51 requires that the governor receives a fair hearing before this House, an independent House, an impartial House. Our passionate plea, and we are sure and we are confident, Senate, without any doubt or equivocation, Senate will rise to that occasion and resolve this matter in an independent manner and in an impartial manner that favors the facts as they lie in these proceedings. I thank you for your time. And my instructions are that we close our case. We have closed our case at this point, but we shall make, the governor himself shall make a closing statement on his own behalf when our time comes. Thank you for your audience, and it's always a pleasure to appear before the Senate.
Thank you so much, the parties, for the submissions. I will now call upon the County Assembly to come and make their closing statement of 60 minutes. 60 minutes, but you don't have to utilize the whole of it. But
yes, Mr. Speaker, we just needed one direction from you before. The governor has handled two elements. They started with their submissions on their preliminary objection, and we wanted to deal with that before we come to the closing, because the preliminary objection dealt largely with legal issues. And I believe that probably we should be allowed a little bit more, but I believe we'll be able to cover all that within that period. My landed senior will open briefly, then I'll come and deal with the preliminary objection, and then we'll come to the closing statements.
Honorable Speaker, members of the Senate,
yes, order, Senator Orengo.
Mr. Speaker, my understanding, according to the directions you had given, is that once they close their case, the governor's case, the County Assembly will now proceed to make their closing statement. They cannot now respond to a case which was being put forward by the governor, because that case by the governor was in response to their case. Yeah, so I think in all fairness, we should go to the closing statements. The County Assembly goes first, and then the governor follows. The only direction probably you would make is after the governor or the Council for the Governors have given their closing statement, do they have a right of reply? I think that's would be the most orderly fashion of dealing with this matter, at least according to your directions.
I think my instructions are that you give your closing statements. That's the direction I've given.
Honorable Speaker, the Senators, my name is Mbuthi Gavenji, and I'll just give a very brief introductory remarks, and then my learned friend, who is also a senior counsel like me, will deal with the rest in detail. The first thing that I would like to confirm is a matter that has been raised over and over again, and I think my clarification here.
What's your point of order, Senator Orengo?
Sorry.
Just as a matter of record, Mr. Gadenji must not put on record something which is false and inaccurate. He is not, Mr. Gadenji is not a senior counsel. The only senior counsels that are in this chamber are only three, and they're on this side of the House.
Honorable Speaker.
What is your point of order, Senator Kabaka?
Mr. Speaker, sir, maybe perhaps my senior colleague, Mbuthi Gadenji, maybe is referring to the pending list, or rather pending and controversial list of the senior counsel, which is before the court.
Thank you. I think make the correction that we need some light moments when we are handling such weight matters also. So proceed.
I would like to say with a light touch that Senior Counsel Orengo was my classmate, and the gentleman seated next to him, Senator Mutura, his father was actually my classmate in Dar es Salaam. So we have 45 years practice, and I'm obliged to appear before you. If I go to the matter in question, I was saying I was going to clarify something that is very important. When the counsel for the governor rose at the very beginning and talked about the preliminary objection.
Order, members, let's converse in low tones.
He did indicate something very important, that the preliminary objection cannot be argued without the evidence. And later, after the challenge, they accepted that this document, which was filed as a PO, or preliminary objection, will take the place of the answer. The first clarification I would like to make, one, they can only rely on this document and argue the 4 points. They cannot go outside the 4 points that are constituted in this document called the preliminary objection. I have had my learned friend go to issues of expunging documents, other documents referred to, but not part of this document. So when you retire at the end of this address, you must confine yourself to this document, which constitute their answer and particulars in response of the allegations. That's a clarification that is essential. Now let me explain something. When then they came with this document, which require a foundation of evidence, they shut themselves from adducing any evidence. And the only evidence they can, the only approach they can take, which is very risky, is to criticize the affirmative evidence that has been given by the way evidence of the county assembly. So what you have been treated to here is criticism of the evidence. Otherwise, there is no evidence whatsoever from the governor. I indicated at the earliest stage possible that the Senate was very magnanimous to the governor. It allowed him a lot of time. He seated here. He never offered himself as an evidence. So as you proceed to look at the submissions of our noble colleagues, you must ask yourself, where is the evidence from the governor? They are riding on the weaknesses of the witnesses that we called. Some of those witnesses produced documents, admissions by the governor in his own hand, admitting unlawful employment, admitting issues that we had put in the affirmative, and therefore, the case scenario that you find yourself here is just trying to poke holes, to concentrate on gaps in the evidence of the county assembly. You should look for positive evidence from the governor. The other issue that is becoming apparent towards the end, and that is towards the submission of my learned colleague, is misinterpretation of who are the parties. The parties here, in accordance to the Constitution and according to the County Governments Act, is the governor and the assembly. This house is not on trial. Aspersions against the House are misplaced. Whether you will grant us the orders we seek or you deny us, you will never be a party to our quarrel between the governor and the county assembly. I have made my own observation. This House is full of honorable members, senior counsels like my learned friend, people who have served in the administration and institutions. I would not, despite my seniority in the profession, make an attempt to make judgment that you are not going to be fair. That is my position, and that is the position of the county assembly. We came here also to seek justice, but we believe justice will come from the documents we have produced, and it will come from the evidence in examination in chief and evidence in examination, cross-examination and re-examination. Short of that, we respect this House. Now, the other thing is that there are general statements that have been made by my learned friends, which we should dispel as you proceed to consider the evidence before you. First, there is no general presumption in law or in fact that if 47 counties have pending bills, they would be exonerated by practice. There is no general practice, there is no rule of law, there is no such presumption. It is equivalent to saying we have all sinned before the eyes of God, but we will hang separately. The other presumption that they seem to say is the rule of precedent. They would like this House to believe that all cases that come, you are bound by decisions that are made by other preceding houses. They are wrong. Every case will be determined on its own merit. There's no general rule at all. In fact, the circumstances under which all those cases are decided, we also take into account the general feelings and also the development in law. You are at the era of zero tolerance to corruption. This is the prevailing best practice. You make a decision that accord with that particular principle that you are here to uphold not only justice, but to endorse zero tolerance. The evidence that we have adduced in detail, the evidence produced. Thank you.
Mr. Speaker, honorable members, when it was a governor's case that the resolution that was passed by the county assembly was not passed with the required quorum. We do not contest the fact that the resolution requires to be passed by a 2/3 majority. You are, however, told from the podium that there were 57 instead of 62 votes, and that's also in the preliminary objection. That's a bare allegation. There are no facts in support of it. You are also told that after the preliminary objection was filed, it was incumbent on the county assembly to file evidence to counter that allegation in the preliminary objection. The sequence of filing documents is set out in the standing orders. In fifth schedule. It is not in dispute that the preliminary objection was filed on the 27th of this month, on the Monday. The requirement under the rules are that when the county assembly receives the invitation from the clerk, and I'm referring here to rule number 7, where the county assembly chooses to appear before the Senate, the assembly shall be required within 3 days of the invitation under Rule 4B, on a date to be specified, to file the required documents there. The timeline that was set after the invitation under Rule 4B was that the county assembly had to file all its documents by Saturday, the 25th, 5 p.m. The governor was similarly required under Rule 6 to have presented his documents by the same time. There would have been absolutely no opportunity for the county assembly to file documents in response to the PO because it came long after the time that was required for filing. So that argument doesn't fly. Now, the documents that the county assembly is required to file when a resolution is passed at the county assembly are set out in Section 33 of the County Government Act. And what is required is that the Speaker of the County Assembly is required to notify, to give notice to the Speaker of the Senate of the passing of the resolution. My learned friend, Mr. Jenga, said that the notice that came to the Senate was accompanied by the notice of motion as well as documentation. That's correct. He then asked, where was the list of the members? There's no requirement in law, in the standing orders, or in the rules to provide a list of the members who voted. And he didn't cite any such requirement. He then went on to give analogies and said that when you have elections, certain elections require thresholds. What I was waiting for him to say is to cite for us any instance in any of the elective offices in this country where the list of voters is required. If you are electing the president, do you have a list of all the voters sent by the IEBC? It is not the case. You do not send the list. So there's no such requirement. Now, the question then arises is, are you required to satisfy yourself that there was a proper resolution? And in my humble submission, the only requirement is for you to receive a notification from the Speaker. And the only time you would be required to inquire into the impropriety is if there had been evidence filed on time that would cast doubts as to what was in the resolution. And there is no such evidence. When it comes to the question of the quorum, as I had submitted earlier and I wish to repeat, the standing orders of Kiambu County make a provision to ensure that if there is any doubt as to whether there are enough members, whether the members' votes were correctly recorded, there is a procedure under the standing orders for specifically that purpose. And the procedure is set out in Rule 98 and 99. Rule 98 refers to an error that is noticed when the county assembly is on the floor. And it says, in the case of confusion or error occurring in the course of a roll call concerning the number or names recorded, which cannot otherwise be corrected, the Speaker shall direct that the assembly to proceed to another roll call. So the anticipation is that if you think there are not enough members, or if you think that there are not enough members as per the threshold, whether it's quorum or threshold, then you should raise that point. And if it is not possible from a tally, looking at what the tellers have brought to determine that question, there would be a second vote. So that is during the occurrence. The second opportunity given to correct any error in the roll call vote is under 99. And 99 is after the proceedings are over. It says, if after a roll call vote has been made, it is discovered that the number had been inaccurately recorded or that an error had occurred in the names of the division lists, the fact shall be reported to the assembly and the Speaker shall direct that the necessary corrections be made. So these figures we are seeing in the preliminary objection. The governor had an opportunity to write to the county assembly and say, the resolution that was passed was not supported by the requisite numbers. And because it wasn't, I would like them to be corrected. That would be the foundation upon which this House would then be invited to ask the question whether the process was followed. Absence of those two interventions, or unless a party comes and says, I did try and I was denied, you would not be required to do so. When Mr. Mbugua was submitting, he made a scurrilous comment about the county assembly. He said, he used a disparaging word to suggest that the proceedings there cannot be trusted. We need, as a country, to respect institutions that we create under the Constitution. And the Kenyan people, in their wisdom, created the county assemblies and created a structure and processes that they are supposed to undertake. It is not up to this House to keep second-guessing communications from the Speaker of the county assembly unless there is a factual foundation to do so. You cannot say that, oh, those are county assemblies, so every time they come, before we can check whether your bill, the bill that you passed is correct, can we see the tallies? Can we see how many people voted? Even the communications from this House, when you have votes, do not require you to send a list of members who voted. Communication from the Speaker about the passage of a motion or a bill is adequate unless there is information. So I would urge the Senate to disregard the allegation that there was no quorum at the county assembly. There's been no foundation in evidence to support that allegation, and therefore no justification for you to interrogate the process. The second matter that the governor raised in his case was that this House should not be sitting and has no jurisdiction on account of the fact that the Speaker called the special session that we are in 28 days after the time prescribed by Section 33 of the County Government Act. Now, the Learned Counsel for the governor asked good questions, but didn't provide the appropriate answer. the first question he asked is there any statute that allows you to extend time? I think that he had jumped ahead of himself. The question for me is not whether you are out of time. It is our submission, first, that these proceedings are well within the prescribed time, well within that time. Further, that if you find that you are in fact out of time, there is law that enables you to extend time and to extend time after. Now, Article 124(1) of the Constitution gives each House of Parliament the power to make standing orders for the orderly conduct of its proceedings. Article 124(1). Pursuant to that provision, this House has made its standing orders. And there are two specific standing orders that are relevant. The first is Standing Order number 28 and Standing Order number 30. Under Standing Order number 28, the time for the regular sitting of this House is from the second Tuesday of February to the first Thursday of December. For purposes of these proceedings, this means that this House adjourned from its regular sittings on the 6th of December. The County Assembly proceedings were on the 19th of December. And the House was not supposed to resume for its regular sitting until the 6th of December. So from the until the 11th of February. So from the 6th of December to the 11th of February, this House was not supposed to be in regular sittings. What does that mean? Section 57C of the Interpretation and General Provisions Act, Cap 2, provides that where an act or proceeding is directed or allowed to be done or taken on a certain day, then if that day happens to be an excluded day, the act of proceedings shall be considered done on the next day following. And the word there is excluded. The act itself does not define what excluded means. And we have very able lawyers here who will tell you that when it comes to statutory interpretation, if the definition is not provided in statute, then you take its ordinary English meaning. And excluded has been defined by the dictionary to mean the excluded would mean that for purposes of section 750, so it is my submission that time does not run for the Senate between the 6th of December and the 11th of February. Now, there is a proviso when it comes to the calendar of this House, and the proviso is in Section 30. Section 30 provides that there can be special sittings of the Senate. And specifically, Section 35 provides that whenever the Senate meets for a special sitting under paragraph 1, the Speaker shall specify the business to be transacted on the day or days appointed, and the business so specified shall be the only business before the Senate during the special sitting, following which the Senate shall stand adjourned until the day appointed in the Senate calendar. So the proviso is that time will stop, but it can be restarted by the Speaker calling a special sitting. So the question is not whether there are 28 days. And time runs only within the dates that the Speaker picks for the special sitting. That is what the standing order says. So once you've designated a date, that is when time starts to run. So when you look at that, you will find that there is really no, the county assembly's notice to the Senate could not have been acted upon until there was a special sitting. So it is my humble submission that these proceedings are actually well within time. However, if this House was to find, before I go to that, this is not unusual, the question of time not running. The High Court usually is on vacation from the 21st of December until the 6th of January. And during that period, time does not run. So this is not an unusual provision. However, if this House is to find that indeed you are out of time, the question will be whether you have power to extend. Again, Section 59 of the same Cap 2 provides that. If you can just give me. Section 59, Cap 2 provides that where in a written law, a time is prescribed for doing an act or taking proceedings, and the power is given to a court or other authority to extend time, then unless a contrary interpretation appears, the power may be exercised by that court authority, although the application for extension of time has not been made until after the expiry of the time. So the question then becomes, is there a statute that empowers you to extend time? And Section 57 of the same act, which I had read, but now subsection D, 57D says, when an act or proceeding is directed or allowed to be done or taken within any time, not exceeding 6 days, sorry, not that. Sorry, it is 57B. If the last days of the period of Sunday, or sorry, in computing time for the purposes of a written law, unless a contrary intention appears, if the last days of the period is Sunday or a public holiday or all other non-official working days, which days also are in this section referred to as excluded day, this period shall include the next following day. Sorry, so that was where I was looking for the non-working days. I was saying that when you are in regular sitting, this is a non-working day. So the let me just have yeah. Yeah. No, that's a different one. I'll get back to the section that gives the Senate power to extend time, but the submission is that, one, you're not out of time, and two, that even if you are out of time, Section 59 gives the Senate power to extend time. Now, let's come to the allegations that the county assembly also was out of time. You are referred to standing orders, the county assembly standing order number 82. 82 2B, and which says a special motion shall be disposed of by the assembly within 14 calendar days. What wasn't read is the beginning of 82.2. 82.2 says, unless the Constitution, any written law, or these standing orders specify a lesser or further period. Now, with regard to the motion, there is a specific standing order that provides a different time from the 14, and that is 84.5. So standing order 85.4 of the Kiambu County Assembly provides that the first step is that there is a notice that must be given. And then it says, upon the expiry of the 7 days after notice is given, the motion shall be placed on the order paper and shall be disposed of within 14 days. So you have two timelines. The first is you give a notice and you cannot take any action until the expiry of 7 days from that notice. And then after the expiry of the 7 days, the proceedings must then be concluded within 14 days. Now, if you look at the timelines that were set out in terms of what happened in the county assembly, the notice was given on the 3rd of December 2019 under 84.5. So from the 3rd of December, the 10 days lapsed on the 10th of December. So the 7 days from 3rd to the 10th. So you had to hear those proceedings within 14 days from the 10th of December. The proceedings were conducted on the 19th of December, which was 9 days. So these proceedings were not carried out outside of that time. So that allegation that the proceedings in the House, in the County Assembly were out of time is not correct. Now, there was a further allegation that there was lack of public participation. Now, again, the question of public participation would have arisen if that had been brought out in the pleadings of the and evidence of the county governor. The question of public participation was not taken up. The standing orders, it's correct, the standing orders of the county assembly do require public participation, and it was done, but there is no requirement in submitting the resolution to the House for the county assembly to submit all details of all the processes that preceded it. So public participation is a process that is done before. If the issue had been raised, it ought to have been raised during the hearing in the county assembly, and if it had, then that would be part of the evidence that would be put here. So for those reasons, I would submit that the issues that were raised as a preliminary objection do not stand. Now coming to the substantive allegations, and because I can see I have very limited time, I will not go into great detail on them. First, we want to confirm that we agree with the Council for the Governor in terms of the threshold, in terms of nexus, and in terms of weight. And it is our submission that, in fact, the evidence before you is indeed weighty. Council suggested that the bundle that we submitted before this House was submitted out of time and contained materials that should not be had. That is not true. The County Assembly is required under the rules to submit its evidence within 3 days of being served with an invitation. And if you look at the wording of the of Rule 7, it says, where the County Assembly chooses to appear before the Senate shall be required within 3 days of the invitation on the date specified to provide the clerk with documentation designating members, indicating the mode of appearance, indicating the names and persons, if any, and a statement of each such witness, and specifying any other evidence to be relied on. So there is express provision that allows one to put in witness statements. Remember that this witness, the county assembly proceedings are by way of notice of motion and may or may not have had witness statements. So you are entitled to produce witness statements. The second thing that you are supposed to do is that you are allowed to bring any other evidence to be relied on. Now, the only limitation that is put on the county assembly is a limitation in Rule 19. And in Rule 19 it says, in presenting its evidence, that is in presenting the evidence that is in provided for in Rule 7, the assembly shall not introduce any new evidence that was not part of the allegations against the governor. So the question is not whether you bring new evidence, but you shouldn't bring any new evidence of new allegations. So counsel for the governor was conflating two things. There's a big difference between allegations and evidence. So there can be additional evidence, provided it comes within that 3 days period. So when counsel submitted that there was an admission that documents were filed out of time, that is not true. We did not file anything out of time. The documentation that has been presented has been done within time. But even when you look at that evidence, the additional evidence that has been presented is still on the same allegations, and except in 1 or 2 instances, for example, the Auditor General report, there was evidence of the various documents that had been submitted, and they are part of the bundle that was sent to the Senate. So there is no breach in terms of the documentation that has been presented. I will then just quickly deal with the questions of the adequacy of that evidence. And I want to just broadly state that first and foremost, in our view, the evidence is completely adequate. I'll start with the one that has the shortest elements so that I can move quickly. The evidence on crimes of a national nature, the CAJ report. We were told by counsel that the CAJ report is equivalent to a newspaper report. That is not correct. The CAJ report is not equivalent to a newspaper report. The CAJ is a constitutional commission and a statutory body. Article 5942 H to J and sections 8B of the Commission of Administration of Justice Act gives the CAJ the power to investigate abuse of office and the power to issue reports on its investigations. So the reports of the CAJ are statutory reports. Second, there has been a determination by the court as to the binding effect of CAJ reports. In Commission of Administration of Justice versus Vision 2030, Delivery Board and 3 others, Civil Appeal number 141 of 2015, the Court of Appeal found that the findings of the CAJ are binding. So the allegations that the CAJ report is not weighty do not arise. You are also told that when it comes to a crime, then you must have a conviction. It's my humble submission that that's not the law. Article 181 and Section 33 are clear that a governor can be removed from office if there is evidence that shows that there is a serious, that the governor, let me look at the article itself specifically, the Constitution. Yeah. so that we get the correct wording. Article 181 says, sorry. And it's important that we get the correct wording, that a county governor may be removed from office on any of the following grounds: where there are serious reasons for believing that the county governor has committed a crime under national law. That there are serious reasons for believing, not that there is a conviction. The Constitution has a separate provision for removing a governor for conviction, which is Article 182, 1D. The office of the county governor shall become vacant if the holder of the office is convicted of an offense punishable by imprisonment for at least 12 months. The framers of the Constitution could not have anticipated that those are the same. So the only requirement under 181 is that there are serious reasons for believing. And the threshold for that, which you are told by them, is that there should be evidence that is more than on a balance of a probability, but not beyond reasonable doubt. And we're submitting that the binding findings of the CAJ are a serious, do provide serious grounds for believing that a crime was committed. In fact, the CAJ in its recommendations went further and recommended that the DPP prosecute. That's how serious the CAJ deemed that fact. Now, when you retire, you'll also see that the CAJ process was meticulous and rigorous. The governor was given an opportunity to be heard. He was summoned. He was interviewed. And he himself confessed in the CAJ report to have irregularly obtained that parcel of land on behalf of his wife, and they agreed that he would return it. And I am not just making allegations from the air. Page 61 is where the governor is interviewed. Page 59 and 62 is where the governor makes the coercion and forces the widow to transfer. Then page 72 is a copy of the green card, which shows that the property was transferred from the widow to the governor's wife, which therefore corroborates the report. And very, very material is that page 72, where you have the green card, not only has the wife's name, but also her ID number. So that we were told by the council that, you know, these people may have the same names. Here you have a person and their ID. Now, you have a finding of a constitutional body. The very least the governor should have done is to get his wife to put in an affidavit and say, yes, I'm Esther Wamoyo Nyato, but I am not that one, because here is my ID, which is separate. So you will find that on that particular account, on that particular allegation, there is absolutely no rebuttal. It is material, and you need to recognize this, that the governor was here and had an opportunity under your standing orders to take the stand on matters that he could avert to. He chose not to. There's a reason why. There's a reason why there has been a concerted attempt to attack these proceedings on procedural matters. It's because he cannot answer to any of the substantive allegations. Now, on the question of the employment, you were told that there is absolutely no evidence that the governor's employment was irregular. that all you have are letters. That's not true. From page 129 to 138 are the letters, but 123 is a memo from the county secretary and head of public service. And it says, the following officers were appointed by His Excellency the Governor and issued with appointment letter signed by him, contrary to the laid down procedures. So you have a designated officer who is the right person who should be able to know whether these appointments were proper or not, who says they were not. The governor had this evidence, but he did not put any responses to it. So on the employment again, we have solid evidence about the improprieties. On the last question of procurement, the county assembly's case on procurement is at 2 levels. The first level is that there was a systematic and consistent weakening of the controls put in place by the law to protect public finance. And it is those that you saw highlighted in terms of over-budgeting, pending bills, as well as the regular procurements. But the case for the county assembly is not that you failed to do all those things. We are aware that this house has held that some of those irregularities are inevitable. It is the purpose for which those weaknesses were introduced that we have an issue with. And you must look at the infringements on weakening the procurement safeguards alongside the evidence that the governor then brought his entire family to benefit from the procurement. It is that combination that is impeachable. We are clear that counties have challenges in streamlining their operations. But in this particular case, unlike in the ones that you've been cited to, there was a method to the madness. And the method was that the beneficiaries of that chaos were his family. Now, when it came to the question of whether when you look at the evidence of Honorable Solomon Kinuthia, he listed all the contracts that had been awarded to members of Mr. Waitito's family. And counsel for the governor stood up, and the only attempt to challenge that list was when he asked Mr. Kinuthia how he knew that this lady, Susan Wangoi, was, Wangare Ndongo was a wife. The first rule of cross-examination is don't ask a question for whose answer you don't already know. He was not aware that the witness had actually attended the Gurario, the actual wedding ceremony. So you have before you testimony of a person who attended the wedding and knows the family. And therefore, there is no question as to whether the people listed are Mr. Waitito's daughters and wife. So in our humble submission, the County Assembly has been able to demonstrate to the required standard that the Honorable Waitito does not deserve to be a governor, has used his office and abused it for his own personal benefit, and the evidence meets the standard set under Article 181, and we would therefore urge that this Honorable House do rule that he is not suitable to be a governor. And I'm going to cede my last few minutes to Mr. Muriuki, who will address the executive one. Now, the issue we wanted to raise was with regard to the procurement, and that is that the governors all received the executive order number 2 and Executive Order number 2, which this House is also familiar with, made a specific provision and requirement of counties that counties were to have a portal in which they were to upload all details of all contracts and procurements and the beneficiaries of those. And we have said that in breaching those requirements, there was a reason. The reason why Governor Waitito's county did not, Governor Waitito did not have that portal is because if he did, then the people of Kiambu would be up in arms when they saw his family providing everything. In fact, when you look at the list of procurements that are set out that were that his family benefited from, which is paragraph 29 of Honorable Solomon Kinudhia's list. When you read this and you realize that this is one family, you would think that this is a conglomerate that is well known because they are doing construction, they are supplying tires, they are supplying garbage skips, they are supplying first aid kits, water supply, garbage collection, protective equipment. Before Governor Waitito became governor, we should have heard about this big family business. Nobody had ever heard about it. And the failure to provide that portal is because if they did, it would be very clear that the governor was misusing public finances to benefit his family. For those reasons, we wish to urge that you do find that the County Assembly has made its case. And on behalf of the County Assembly and my colleagues here, I would wish to thank the Senate and the Speaker for your patience.
Thank you for your submission. Now I invite Governor Waitito to come and make his closing statement.
Honorable Speaker, much as we had indicated that Governor Waitito will be the last to go, I feel that will not be doing justice to his case if certain comments that have been made by counsel for the Assembly are not answered to. I noticed, Mr. Speaker, that we also had an hour in making a closing statement. We had not anticipated some of those issues would arise. So I would urge, Mr. Speaker, that I take a few minutes, of course not the 1 hour, just a few minutes to clarify a few things, of course as part of our closing statement. And then Governor Waitito will address the Senate. Mr. Speaker, when Mr. Mbuthi Gathenji was addressing this Senate, he adverted to the fact that a PO cannot be the basis of contesting the question of numbers, or rather, in the absence of an answer, there cannot be any basis upon which we can urge the issues that are raised in our PO. Mr. Speaker, even without referring to the technical nature of a PO, it is a pleading that the governor filed, and it contested the issue of numbers. Mr. Speaker, the moment that PO was filed and admittedly served on the Assembly, then it behoves the Assembly to lead evidence on the issue of numbers. I'm glad that Mr. Nani Mongai has said that there should have been some intervention in form of a letter. In fact, he has gone ahead to say that the only time this Senate can investigate numbers is if a letter was done. Mr. Speaker, a letter was done way back on the 23rd of December to the Speaker of this Honorable Senate on the unprocedural nature of the impeachment that was conducted by the County Assembly of Kiambu and it was received. This is a matter of fact. It was received by the Speaker's office, by the Senate, on the 23rd December 2019. It was raising issues of improprieties that were committed. In fact, it says that with respect to the captioned matter and procedural impeachment of Honorable Governor of Kiambu, we noted the following improprieties. So this letter is there. It detailed how the voting was done, the numbers that were present, and the governor, through his advocate, Ndegwa and Ndegwa Associates, was actually bringing this matter to the attention of the Senate. This letter is before the Senate. It was served, and it has a stamp. And that was before this impeachment commenced. So it is not entirely correct that this issue has never been raised, Mr. Speaker. But let me just add this, because you've been told that you cannot investigate, or rather the only time you can investigate is if that question is contested. First, we have shown it has always been contested. But what's the purview under Section 33? At the risk of belaboring this point, Section 33(3)(b, once the Senate is seized of this matter, the Senate shall investigate. It does not say it shall investigate only in certain situations, Mr. Speaker. Your investigative powers while sitting as an impeachment court is not limited to matters that we can bring before you as the litigants. You can delve. We have participated, Mr. Speaker, in impeachments where the Office of the Controller of Budget has been summoned to shed light. COB was never a party. The Office of the Auditor General has been summoned. That office was not a party. But it's because the Senate, in its wisdom, wanted to get to the root of materials relevant to the impeachment question before it. So it cannot lie, Mr. Speaker, in the mouth of the Assembly to limit your scope and say, oh, don't go beyond this because this question is not contested. It has always been contested, and we have demonstrated that way back in December 2019, that question was, that issue was raised. The issue of burden of proof, Mr. Speaker. Again, you were told that in the absence of evidence by the governor, I heard Mr. Mbudi Gadenji to say that in the absence of our evidence, then their case is uncontroverted. Mr. Speaker, even when the governor does not adduce any evidence, it still behoves the Assembly to discharge their burden of proof to the required standard. So that let it not be said that if we do not tender evidence, like what happened when our request was declined, Mr. Speaker, with due respect, it cannot be that then any case presented by the Assembly, even in the absence of the evidence of the governor, must prevail. The standard, the threshold, the nexus, and all the requirements must be complied with and must be discharged by the Assembly, Mr. Speaker. Mr. Speaker, we did not criticize the Senate. We respect the Senate because it's comprised of noble men and women of character. Mr. Speaker, an expression of dissatisfaction with a determination is not out of disrespect. We respect the Senate, and we know and we trust and we have confidence that it will be able to consider this matter objectively and arrive at a just determination, Mr. Speaker. Mr. Speaker, the other issue that I'd like just to deal with is, Mr. Speaker, just on the issue of the evidence, we are all in agreement about threshold and nexus. But Mr. Speaker, you have been told that since there is a report which is binding, yes, we agree it is binding, but I'm glad that Mr. Nani Mongai read a recommendation that the office of the DPP was being requested to prosecute. Perhaps a question needs to be asked, why wasn't there a prosecution? Could it be that further investigations were conducted And it was actually found that there was no basis upon which those that had been adversely mentioned in the report would have been prosecuted. That's a question that this Senate needs to grapple with. And in our humble submission, Mr. Speaker, it may very well be that lack of that prosecution is indicative of the fact that there was really no reasonable basis upon which charges would have been pressed against the governor. Mr. Speaker, on crimes, again, under Article 181, yes, we agree. It is reasons to believe that a crime has been committed. But can we then say that in a situation where no prosecution was commenced, even after a recommendation was made, constitutes sufficient basis to believe? Our humble submission, Mr. Speaker, is that it does not. And that is why it does then not rise to the threshold required in terms of Article 181 of the Constitution. You are told about evidence of kinship. Mr. Speaker, it is important to point out that those documents about CR12s and about family members is to demonstrate or to prove an alleged charge of conflict of interest. First, we raised an issue of sub judice, which is a very important legal principle. Does this Senate now wants to wade into a matter that is currently the basis of active prosecution? Number two, you're now told that merely because somebody said he attended Angurario, that he did not even have pictures to show that he was actually in attendance, should now be taken to be the truth of that statement, that in fact there is evidence of kinship. That cannot be true, Mr. Speaker. There has to be a higher standard, Mr. Speaker, not simply a CR12, allegedly that bears one name that resembles the name of the governor, Mr. Speaker. On the issue of employment, you've been told that because there is a letter from the office of the county secretary alluding to the fact that some of those persons may have been...
Order. There's a point of order from Senator Cheriot.
Mr. Speaker, I interrupt what is being presented, but there's a word that has continually been used both by the Assembly and now by the Executive, which does not fall under the purview of either English or Swahili, which are the language of instructions in the Senate. Perhaps you need your determination, if it is okay for them to continue to use it, and for those of us who don't understand that language, for us to be given a...
Which word? You're also being vague.
Something gura. Yeah, please. We don't understand what it is.
Council, proceed.
Thank you, Mr. Speaker. Council Nani Monga.
Okay, there's another point of order, Senator Maina Ephraim.
Mr. Speaker. Yes, let him. Mr. Speaker, thank you. This is not a matter to prolong, but as you know, these learned friends are capable and they continue quoting some Latin quotations. And Mr. Speaker, Gulario has no other interpretation in any other language. It is something that it denotes a process, it denotes the weight of the ceremony, and it has to be termed that way. In the event anybody may wish some small explanation, it could be provided by text.
Senator Kabaka, what's your point of intervention?
Thank you, Mr. Speaker. Maybe for those who are lawyers here, in the usual university courses, there is a paper known as the family law, and there is a landmark case known as Runguru versus case versus Runguru, where the issue of capacity was called in question, where a white man who did not have capacity traveled to Kenya and married a Kikuyu lady, and the issue was that while nullifying the marriage, the court held that the process of ruratio was not followed. Ruratio here means, like the distinguished senator of Nyeri has said, It's a Kikuyu process of yes. Yes. So, Mr. Speaker, sir, this is not a semantic, like we said, it's a customary requirement where the parties undergo. If you are Kikamba, would give the meaning, but it is not an issue here. Thank you.
Senator Mohammed Haji.
Mr. Speaker, sir, those who don't understand Gorario need not be text, as my brother is saying here. Those who are interested should get a lady to marry, and then it will be performed, and they will see what it is.
Senator Wambua Enoch, what is your point of order?
Mr. Speaker, I hear the comments by Senator Haji, but unfortunately, Mr. Speaker, there are those of us who are interested in understanding the meaning of Gorario, but you're already married. So how will you get to know about the meaning of this word, Mr. Speaker?
Okay, for us to make progress, Council, maybe you can explain what your understanding of, just for the benefit of the House, as you proceed.
Thank you, Mr. Speaker. I don't wish to authoritatively speak about the nature, meaning, and purpose of Ngurario, but it has to do with a traditional, it's a ceremony, I gather, that consummates a traditional marriage. I could be right, I could be wrong, but that's my understanding. Mr. Speaker, I was at the point where I was making reference to the allegation of failure to comply with the law regarding recruitment of employees. And Mr. Nani Mongai has, in an attempt to demonstrate nexus, made reference to a memo from the CS, Kiambu, which allegedly refers to persons that were employed without compliance with the law or the laid out procedures. Mr. Speaker, what this Senate perhaps needs to ask itself, why this particular county secretary could not be summoned to come and testify so that we can question him further on the content of that memo. Otherwise, a memo without more, and considering that a member of the County Public Service Board who had been designated to come and testify did not testify, then this Senate should be reluctant or should be careful in making a finding of impropriety in those circumstances, Mr. Speaker. Had the CS come and shed light on this question, we would have cross-examined him on it or her on it, and this Senate would have had all the full facts of these allegations touching on recruitment of these casual workers. On the issue of procurement, Mr. Speaker, and this was sensationalized, it was alleged that in our cross-examination, we only asked questions that did not touch on this matter. Mr. Speaker, in our cross-examination, one of the things that could not be demonstrated by the Assembly is which are these contracts that were issued and who issued them. Were they issued by the governor? There was no evidence of that. Now, what I heard Mr. Nani Mongai to say, there was systematic weakening of controls. That should be a deliberate action. There should be evidence of in what manner and nature did the governor systematically weaken the procurement processes and controls within Kiambu. You have not been shown that evidence. But now you're being told speculate and make a finding that there were, in fact, these issues, or rather there were these transgressions, and they were all intended to be or to benefit the governor. You recall that the main allegation as far as this tendering is concerned was on kickbacks, Mr. Speaker. And you recall that we posed a direct question to their witness, and no evidence was tendered that in fact the governor benefited from award of these tenders and these contracts that they could not even prove were issued in the first place, Mr. Speaker. As I wind up so that I can yield a minute to Mr. Jenga, the issue of precedence. Yes, we agree that each matter must be dealt with on the basis of its own merits. A matter rises and falls on its own merits. That we agree, Mr. Speaker. But what we were saying is this, that the Senate has had occasion to deal with matters that touches on, for instance, bills, pending bills, and it returned a certain verdict. Same set of facts and circumstances. And we are asking that the same stick that was deployed in that matter be deployed in this matter. Article or Standing Order 1, 2 of this Senate standing orders indeed recognizes the purpose of forms and precedents. You may not be bound by previous determinations regarding previous impeachments, but they are persuasive in great respects, especially where you have matters that falls in all fours to those that are before the Senate, Mr. Speaker. So I'll yield a few minutes to Mr. Jenga just to touch on the question of time, because it was adverted to by Mr. Nani Mongai, on whether, in fact, you could have extended time to consider the resolution that was passed to the Senate by the Assembly. And then the governor will wrap it up, and that will be the close of
Senator
our case.
Cherargei, what's your point of intervention before it comes?
Mr. Speaker, sir, on a point of order, Standing Order number 99, a senator who wishes to speak on any matter in which the Senate has a pecuniary or proprietary interest shall first declare that interest. Mr. Speaker, sir, if you see, I have seen my colleague of Murang'a, Senator Irungu Kang'ata, having cross-checked online and everywhere, is one of the partners in Mushoki, Kang'ata, and Jenga and Company Advocates. So, Mr. Speaker, sir, I hope when we'll proceed even to voting on other decisions of the House, we will need a ruling on how or why, where we can release Senator Kang'ata from not participating in the final deliberation of this matter. I thank you, Mr. Speaker.
Okay, I will make a determination at that point. Proceed. You know how to ask for. Okay, proceed.
Yeah, thank you, Mr. Speaker. Allow me to respond to that issue because it's a very weighty issue. Mr. Speaker, allow me to respond to that issue because it's a very weighty preliminary objection. Mr. Speaker, I affirm that indeed myself, Irungu Kang'ata, and Mr. Charles Jenga, we have had a long pecuniary relationship in the form of Mushoki, Kang'ata, Jenga. But in respect to this matter, we have met, and I hereby declare I do not have any pecuniary interest in this matter, and therefore would be asking you to find that that rule does not apply in this instance. Mr. Speaker, yesterday and the day before yesterday, we had a very long discussion with my friend Charles Jenga concerning this matter. I had made an effort for him to excuse himself in acting in this matter, but we agreed that for the purposes of that rule, and because I have an obligation to the government that is led by His Excellency Uhuru Kenyatta, by which it has appointed me as its Deputy Chief Whip, I really need to come in this house and do my duty. And therefore, I ask, let that rule not apply now, and therefore I don't have any interest in this pecuniary interest. Thank you.
Order, members. First of all, this matter is not on record. It's premature, and when it comes up at the right time, we will address it. So proceed. Yeah, proceed.
Thank you,
I
Mr.
hope not
Speaker.
on that matter because I've ruled. Proceed.
I hope, Mr. Speaker, we shall recover the time that has been taken by the interventions. I think it was about 1 hour.
You said you are going to use less than, in fact, you said you are going to use less than 1 hour. Just try to condense what you have, Council.
Now, I only have 1 point. And then His Excellency the Governor will address the Senate. And my only response in summing up is the question of time. There has been a submission that under the standing orders of this House can circumvent the operation of statutes. The suggestion is the standing orders rank higher in profile of application than the County Governments Act with regard to timelines. Far from it. That's a very, it's what we call sophistry, a very good argument, impressionable, but legally dishonest. The County Governments Act does not provide any discretion for the extension of time. It is very different with, for example, the Civil Procedure Act. Within itself, it says the court can extend time on certain circumstances, and then the rules at Order 49 provide for those circumstances. That similar provision is not available in the County Governments Act. And we need to be honest in our submissions, much as we want to quickly dispatch Governor Waitito from his position. But another better analogy will be the Elections Act. The courts have said the courts have no discretion to extend time even for a day in the matter of elections. In fact, the Supreme Court said in Raila Odinga petition number 1 that even if a ton of evidence was to be availed on the 8th day, that petition would not be admissible because Article 40 says 7 days from declaration of elections. Section 33 says 7 days after the Speaker of the County Assembly transmits to the Speaker of the Senate, which was 23rd. So under which provision are we saying the standing orders extend to in the matter of extending time? There is no provision, and the proper reading of the law, and I'm glad many speakers have adverted to the fact that the House has many senior lawyers, more senior than me. The proper reading of this particular statute shows there is no discretion to extend time. In the Limitation of Actions Act, if you look at Section 27, it gives a leeway. It says the court can in these circumstances. Those are distinguishable statutes from the County Governments Act. The other issue that was raised was public participation, and it was alleged that we did not contest. We filed a preliminary objection contesting that as an issue of law and fact. Once you plead not guilty in a proceedings of this nature, which are quasi-judicial, quasi-criminal, then all the material issues become issues that should be evidenced by the alleger. And the person alleging is the county assembly. So they should have demonstrated, as provided in the standing orders, that before they brought this resolution, there was a process as constitutionally provided for public participation. On the question of the standard of proof of occurrence of a serious likelihood that a governor has committed a crime in the contemplation of Article 181, the Senate has ruled consistently that it will be opening a Pandora's box to make that an impeachment issue based on mere allegations. And the Senate has said on that article, then you will need to show us a conviction. I will, on the question of additional evidence, there has been a splitting of hairs on semantics of allegations and evidence. Allegations can only be made by way of evidence. So a case against a governor should not mutate should not change in the nature, in the manner, in the weight of evidence from the county assembly all the way to the Senate. And therefore, that rule by itself, properly construed, would mean that there would be no instance of additional evidence alleging certain facts or certain things about the governor. That, in the admission of the county assembly, has been violated. They say we brought in new evidence that was not before the county assembly. That makes the entire proceedings and the entire resolution manifestly unconstitutional in the contemplation of Article 50, Rule 1, and we urge that you consider those facts and find that the case against the governor has not been substantiated. If all other governors were held to account on the basis of the standard of the law, 7 days after dissolution, they were brought and tried, then that should be the same standard should be applied to Governor Waititu. And I welcome honorable senators through the Speaker. I welcome my client, Honorable His Excellency the Governor, to make the final close of his case. Thank you for your time.
Thank you, Mr. Senator, Mr. Jenga. And I want to take this opportunity first to thank the Speaker of the Senate, together with the senators, for listening to us, being patient for all this time. And before I proceed, I just wanted to bring to the notice of the Speaker that there is a tweet that was made by one of the senators, somehow concluding as if you have concluded the whole matter. And I wonder whether it is proper for tweets when the process is going on. I have in my possession a tweet by Senator Mwaura alleging that we have rejected Waititu to file evidence out of time as he was requesting. He has not filed any defense, and he waited for all the matters to be raised for him to want to open the case afresh. The people of Kiambu and Kenyans need justice. Waititu must face the full force of the law. No mwizi, no thief should go unpunished. I think you have not concluded that I'm a thief, Mr. Speaker, sir. Please, this is the spirit that has been going on in Kiambu County. And this is what I said yesterday from the beginning, that this honorable house, from today henceforth, they must make a ruling that will change the narrative of Kiambu residents and the readers, because they have made it to the level that they are professional demonstrators in Kiambu and professional bloggers, people who wake up every day to malign other people's names without any consideration of the rights of any person. I'm a married person, I'm a family man who should be respected by all means. Nobody should conclude that I'm a thief. Just like that, honestly speaking. I have a right. I have a right, like any other Kenyan, to be respected. And if I may remind you, because you have gone the same process that I went, rigorous campaigning to be where I am. And this is something I have done when I became the councillor of this city and the deputy mayor, became the MP for Embakasi, I became the MP for Kabete, and now the governor of Kiambu. Not mentioning, I try to be the governor of Nairobi. I'm somebody who has worked hard, who should be respected, and somebody who knows what it is all about to have a seat and take care of it. So, Mr. Speaker, sir, when you are considering, together with the honorable senators, please consider that I'm not somebody who just sneaked to be a governor. Honestly speaking, from the deliberations I have had from yesterday, my considered view is that in future, all speakers that bring a motion to the Senate should be the first witnesses so that they can narrate and be cross-examined on the motions that they bring to the Senate. Because it is very, very unfair. It is ungodly for me to work the way I worked, to be where I am. Then I'm removed unceremoniously, like somebody, because I'm maybe not in your political right position as you might. And tomorrow with the politics, I might change and be with you. Who knows? We have been changing parties. Nobody knows what will happen tomorrow. So you cannot judge a politician from what was happening last week or yesterday. You don't know what will happen tomorrow. So honestly speaking, I beseech you, honorable senators, that don't judge me from what happened or what is prevailing now. You might be very surprised with what will happen tomorrow and the day after. So please, honestly speaking, handle my case like any other case that has come before you, the 7 previous impeachment motions that came before you, and you handled them with dignity and integrity. Honestly speaking, I had a lot of difficulty compiling the evidence, considering that I'm out of office. I have been barred to be in office. And I was the first, in fact, we are the first governors to be barred to be in office. It is a new experience. It is a new exploration by even the judiciary to get governors out of office. It is the new. But what I did, honestly speaking, I did a lot of photocopying for the evidence. We did a lot of work throughout the 3 days. We have 240 copies of those answers for all those questions lying in the Sergeant-at-Arms office since Monday. And it was our belief that they shall be admitted, just like the way they had been admitted before. So honestly speaking, I am surprised. But as Mr. Orengo said the other day, a clip that went viral, that the governments of revolutionaries eat their own citizens. What you will do today, what you will do today to Waitito, because you will become governors yourself, it will also come to haunt you yourselves. So honestly speaking, you must be just. Just consider that justice is for everybody. And honestly speaking, I was not given a chance to be heard in the County Assembly of Kiambu, despite sending my lawyers. And it is in the standing orders. What else could I have done? I sent my lawyers, they were there on time, they were recognized from morning, and they were not given any chance to be heard. That alone, honestly speaking, that is a violation of their own standing orders. And even if I'm not a lawyer, but honestly speaking, that one is wrong. I wrote a letter to the Speaker detailing everything, and it was received on 23rd. And I wrote clearly in that letter that we have affidavits of 35 MCAs who did not attend that assembly. And they are there. And if you can send for the documents here, you'll see the affidavits. Honestly speaking, what other truth can the Senate look for to be just? This is a very, very important house in this country. You are very important people that every Kenyan look for. We look up on you to give us livelihood when we are suppressed elsewhere. But honestly speaking, if it took more than 14 days for the motion to be deliberated, and it is clearly stipulated that a special motion must be dispensed with within 14 days. That is a great violation. They came to the voting. There were only 57 members of the county assembly in that assembly. The law requires that they have 2/3 who will vote for yes. Seriously speaking, even if you don't like Waitito, but the numbers are on my side. The numbers, and everywhere, because I have been in these assemblies as elected member, I know numbers everywhere. You are a senator because you are elected, and numbers were announced so that you became a senator. The same with me. I became a governor because of numbers. Numbers are supreme in every case. They are cardinal. You cannot ignore numbers. Honestly speaking, Mr. Speaker, sir, I beseech this House to make a ruling that cannot be challenged in any court of law, so that everybody would admire to be a senator. Like me, I thought that when I am through with Kiambu, I'll become a senator. Honestly speaking, yes. I know I'll contest and I know I can get. Yes, I'll be a senator one day. Because my strongest belief is that this House, when I was part of the people who are making the Constitution, I was in Parliament here. I was in this Parliament when the Constitution of the devolution was made. And honestly speaking, people never thought there was going to be any cheating in the county assemblies when people are being impeached. It is a new discovery. There is nothing like that. Nobody expects something like that anywhere in the world. That a lying can be done at the county assembly level, then it comes to the Senate, and such an important thing, such an important issue, the basis of impeachment is ignored. Honestly speaking, just consider my case the way you would like yours to be considered when Waitito will be the senator here. Mr. Speaker, sir, the lady who alleges that there were malpractice, that I participated, has not made any complaint in any police station. Mr. Speaker, the lady was not called here to testify. In her affidavit that was read here, it did not mention me. It mentioned some county officials, not me, not Waitito. Again, Mr. Speaker, the authors of that document, the ombudsman, were not called in this assembly to testify that it is true that that document is genuine from their office. They could have been called. This is an important matter. Getting rid of somebody who was elected with over 800,000 votes. You can imagine going around 12 constituencies to be elected. Honestly, such an important issue. The ombudsman could have been here. They show the evidence where I was involved, whether there is any document implicating me. They never called me. I have never seen them. I just read in the newspaper. I have never seen them. Honestly speaking, if they were called here, it could have been very good so that they are cross-examined, Mr. Speaker. Mr. Speaker, sir, the gentleman who gave evidence here, as the second witness, Mr. Eric Kiriko, has been the Public Service Board member in Kiambu County for the last 6 years. He is the person who was the right person to answer the questions about employment. He could have given the first-hand information. He has been a member for the last 6 years. And honestly speaking, right now, he is employed by the deputy governor against court order, which I have here from Justice Macau. that Mr. Nyoro, as a deputy governor, he cannot nominate, he cannot employ, sack, or even transfer anybody in the Kiambu County. But he has gone ahead to employ over 50 staff. Some of them who are bloggers. Their daily work from morning to evening is to do blogging, to malign my name. Honestly speaking, that is the person who was called here as a main witness. He is an illegal employee as per the order from the High Court. Mr. Speaker, sir, that is as per Employment and Labor Relations Court petition number 172/2019. And there is a very clear ruling on the orders. Mr. Speaker, sir, all the allegation by the county secretary that the letters I signed for 26 staff members, whom some of them were working in my office. I think 5 of them were working within the headquarters. Mr. Speaker, sir, was not called to testify on the irregularities that he mentioned. How can you believe such a letter? He could have come here and taken a Bible to testify that it is true that there were irregularities, and he mentions what type of irregularities they were, Mr. Speaker. Mr. Speaker, that was not done. Mr. Speaker, sir, the Kiambu Public Service Board has 3 members presently. It doesn't have a quorum, but it has 3 members. None of the members was called to testify on the irregularities that I am assumed to have done in employing the cashiers. I'm not part of the Public Service Board. All those members were recruited by the County Public Service Board. Mine was just to give them a letter in a ceremony in the last day of that appointment. But they had gone through the process of recruitment by the County Public Service Board. The same with the cashiers. They were given letters by the Public Service Board. They were interviewed by the County Public Service Board. Mr. Speaker, I urge this House that justice be done to all of the governors who will ever come in front of you. Mr. Speaker, sir, if you look at those documents, you will see that they are signed by different people. They are not only signed by one person, and I'm one of those persons. Some are signed by the county secretary, some have signed, some were signed by the secretary to the County Public Service Board, and it is therefore not peculiar for me as a governor to have signed those letters. Mr. Speaker, on the allegation of influencing tenders, Mr. Speaker, there is no evidence that was adduced in front of you to suggest that I was given any kickback in those tenders. Mr. Speaker, all of you know that when we are campaigning, we promise our people roads, to make roads for them. And it is not peculiar to Kiambu alone. Every elected person when campaigning, they say what they will do in the future. I said exactly that, even me. And honestly speaking, if you have the chance to visit Kiambu, you go and see Juja Road, the Gatuanyaga, Munyu Road, Kenari in Kamai Road. You see the road in Odhiru. You see another road in Ruiru. You see the desperation of those people for many years. Mr. Speaker, sir, for those procurement staff in my county who went ahead to advertise those tenders, Mr. Speaker, sir, I would like the senators and you yourself to understand that these projects were not being done in one financial year. They go in 2, 3 financial years. And that is why when they are quoting, they quote the whole amount, but it will be in different budgets, 2 or 3 budgets before the roads are completed. So, Mr. Speaker, you cannot blame me, honestly, for a road that was not built for myself. They were to be built for Kiambu people. And honestly speaking, I will repeat it again, that to be elected, you have to give promises, and to execute the promises is not that easy. As a governor, I thought my most important thing is to spearhead the county to achieve development that we had promised our people. And therefore, Mr. Speaker, in absence of any evidence that I got any kickbacks from those tenders, honestly, you cannot take that one as an evidence against me. Mr. Speaker, on the budgeting, we have very qualified staff in Kiambu County. Some who have masters in procurement, some who have PhDs. Those are the people who should have answered any question concerning budgeting and procurement. I'm not a procurement staff, Mr. Speaker. I don't belong to those committees. There are people who are entrusted to do that. Mr. Speaker, to sum up what I had to say, Mr. Speaker, the first witness who was here, and I think he's still here, I can challenge him, Mr. Speaker, sir, to produce any document to show that he has a master's degree, or he is a member of CPAK. Mr. Speaker, sir, this House must demonstrate that Kenyans need to be told the truth always by leaders. You should not entertain liars and propagandists to find their way in the assembly, in the Senate. People should know that Senate is a very, very respectable house with people of great integrity, and whatever somebody comes to tell the Senate here must be the truth and nothing else but the truth. It is also important to mention, just to show how gravity of lying in Kiambu is high. My deputy governor has been going everywhere saying that he's a doctor. He doesn't have a PhD. Mr. Speaker, sir, this House must demonstrate and teach Kiambu a new lesson of saying the truth. Deceit, propagandists, honesty in this country must be discarded. Mr. Speaker, somebody talked about a case and this time that zero tolerance on corruption. I have not been convicted. I'm still innocent until proven guilty. Even our president said that in the church the other day, that all those people who have been accused are still innocent. And I believe you, as our senior people here, senior lawyers, whom we have been reading even in school, whom we admire so much, please make sure that you do justice. Make sure that you follow the law and the Constitution, so that your legacy and those people who admire you out there, who go to the school of law to learn to be like you, can learn day and night to be like you. Because you are admired out there by people who would like to see you themselves one day looking like yourselves. Mr. Speaker, I hope that this House will consider that I had the evidence. I have the evidence. It is around in the compound of the Senate for the last 3 days. Mr. Speaker, I had written a letter to you immediately after the Assembly of Kiambu did what they did, and I detailed everything. And the letter that the lawyer for the Assembly talked about, everybody must know that that letter had been written on time, and I expect that justice will be done to me like it has been done before to the other governors. Thank you so much, and God bless you. For those who will be governors, remember that MCAs sabotage everything until you bribe them. It is a serious problem handling MCAs. Therefore, honestly speaking, the first witness here is the one who had taken our budget to court. Kiambu stalled for 6 months because our budget had been suspended. Just because he tells people how he's run it, which he doesn't have any document to show. Mr. Speaker, please, issues of MCAs, future governors, I'm now telling the future governors, please know that handling MCAs is a huge task. And I urge you, please consider myself as somebody who is handling that matter, and also somebody who is in Kiambu, where there are propagandists and liars, where there are people who believe in succeeding by whatever means without using the right of means. This case of mine, honestly, is supposed to be thrown away by the Senate, and I urge you to do what you would like to be done to you under my circumstances, under the circumstances that I'm in. Thank you so much. Thank you. Thank you, Mr. Speaker.
Okay, other members. On a light note, I want to, other members, to tell Governor Waititu that I hear you because I've been there before. Honorable Senators, now Governor Waititu did raise an important concern about Senator Mwaura. I'll also be making a communication in the course before we close the sessions, because it's very unfortunate if that happened. So I'll now suspend the session for 15 minutes to allow senators have a short break. Then after that, we shall come back for a closed session discussions. And after that, we'll reconvene after the camera session for voting. So I want to thank all the parties that have been here. I want to thank the senators for your patience. And I want to assure the parties that the senators have heard you, and they will be discussing the issues based on what you have said here, and each one of them will have to make a decision at the end of it. So thank you very much. The session stands suspended.